Let's call the list. কত number? Yes. Yes, naturally. No, later. First monthly list I will exhaust, then the daily list, sir. It's normal procedure. So people have been waiting for months together. So what will happen? Difficulty is this, sir. If I take up the daily list, then these list matters. Some exception will be made. There may be matters which will be returnable. Those are different, sir. At least indication will be there, Mr. Mukherjee, in the list. Yes, call the list. ওটা দেখে নাও, নিয়ে নাও কাজের কাগজে। Yes, yes.
I am appearing for the petitioner, my lord.
Yes.
The prayer is for expeditious disposal. My lord, the title suit was
Yes.
filed on 22nd of February 2021
Yes.
by the petitioners. For
21 you filed the suit.
my lord,
Yes.
for declaration.
How many adjournments have been taken by the defendants?
The total number of adjournments have been taken on 6 occasions. On one occasion, the defendant remained.
Let me find out where is the entire order sheet from
My lord, the entire order sheet I have annexed.
Where is that?
The certified copy. My lord, it starts from 3rd of March 2022. The order starts.
Service of summons is complete. Service of summons is complete.
My lord, the service of summons is complete. The next date is
When was service of summons completed?
The interim injunction was granted on 23rd of February 2021. My lord, on at page number 75 it is there.
WS filed.
My lord, written statement filed.
When?
My lord, the written statement. It was filed on, my lord, 23rd of September 2022.
Twenty?
23rd of September 2022.
Why did you file an application and then not proceed, sir? Your injunction application is yet to be disposed of, and I will direct expeditious hearing of the suit.
On 15 occasions.
Sir, your injunction application is yet to be disposed of. Have you seen that?
My lord, it is yet to be disposed
What to have indicated that? And you are seeking for expeditious disposal of the suit. Sir, ensure without disposing of the injunction application, the learned judge will hear out the suit, sir. What do you want? Tell me. Tell me, sir. Sir, why have you filed this application? Come to the order sheet just prior to the power of attorney. Tell me whether the injunction application has been disposed of or not.
But the injunction application has not been disposed of.
Then What steps have you taken in the suit, sir? What steps have you taken in the suit, sir?
Not kindly consider, my
No,
lord.
no,
We
you
had
tell me
paid
what
for
steps have you
enrollment.
taken, sir? Have you made any application for filing of your affidavit on evidence?
My lord, that application I have not made. I had
Then?
filed an application for early hearing, my lord.
Early hearing of the injunction application, sir.
My lord, early hearing of the injunction.
I've read it, sir.
My lord.
Then you want disposal, early disposal of the suit, sir. This will not be permitted, sir.
My lord, also of the injunction
No.
application, my lord. If that can be granted, kindly consider also for the injunction application.
Where is your prayer?
My lord, at page number 12. The early disposal of the application, my lord, and also the application for injunction, my lord.
Considering the relief sought for, the present application is taken up for consideration without service of
Right, I am appearing for the petition.
Yes.
No, this is an application for expeditious disposal of an application filed under Order 1, Rule 10 by my client in connection with the
Order 1, Rule 10 for addition of party.
for additional part. I tell you,
Addition of,
Lordship,
which party?
but I am nobody in the suit. I am a successful auction purchaser. I purchased the property from Oriental Bank of Commerce, which is now Malad Punjab National Bank. Sales certificate has been issued in my favor. Now, Malad, after waiting for a long, in August 2023, for the first time, I came to know that there is a suit filed by the opposite party numbers 1 and 2 before your Lordship, inter se between two rival parties, claiming to be the possession of the suit property and impleading the bank as a party therein. Now, my lord, I understood that the bank has already filed a written objection to the injunction application filed by the plaintiffs, and in the written objection,
Who
they
are
are,
you?
I am a stranger purchaser.
When did you purchase the property?
I purchased the property. My lord, kindly look
Whose
at
suit? Plain bank filed a suit.
bank filed a suit, bank obtained a decree. After that, the suit has been filed by the plaintiffs. My lord, kindly look at the sale certificate. Kindly look at the sale certificate at page 37. My lord, sale was confirmed on 8th of September 2014
Yes.
in my favor
By the bank.
by the bank. By the
Yes.
bank, I went to paid the entire money. Sale certificate has been issued. I was not aware of any suit. Now, later in 2023, I came to know that there is suit inter se between the parties. They are claiming to be owners of the property, impleading the same bank who has sold this property in my favor, who is the defendant number 1 in the said suit. And
Seeking for cancellation of the sale certificate.
no.
Then
They are only asking for restoration of possession from the bank. Bank has obtained
Bank
possession
cannot
under
run.
section 14 of the
the
Service
bank
Act.
cannot run. So how are you concerned, sir? Why do you want to step in?
Well, because the order of status quo has been passed, bank cannot give the property to me.
My
Although,
sale certificate has been issued.
yes, but bank cannot take any steps because of the order of status quo. And I don't know what steps bank is taking. Bank is not taking any. Kindly look at the sale certificate once.
The petitioner is aggrieved.
I am only praying, Lord, I am a necessary and proper party. I am only praying your Lordship will kindly direct the order on
Petitioner
rule
is
10
aggrieved.
application to be hard expeditiously. Nothing more I want. I am a necessary
When did
party.
you file the application under Order 1, Rule 10?
My lord, that I have annexed.
When did you file it?
My lord, I filed on 15th, 19th of May 2023. 19th of May 2023 at page 12 I have stated. I have annexed the application under order on rule 10.2. 19th of May 2023.
Where does it reflect in the order sheet?
My lord,
Where does it reflect in the order sheet
From
that
the
you have filed the
entire-
application?
the entire order sheet I have not, but I have annexed the application.
No, sir.
I have annexed the application.
No,
Kindly
sir.
look at the
No,
application.
sir. Without the order sheet, I will not, sir.
My lord, the information, kindly see the information I have annexed, the last annexure.
Sir, is it, tell me, sir, when an application is filed, will it reflect in the order sheet?
Yes, it is reflected in the order sheet.
No, I'm asking you.
My
Will it reflect in the order sheet? Have you moved it? Unless you move it, you file it, nothing will happen. It
But
has
I
to
have
move.
filed, I have served all the
Moved
parties,
it.
and my lord, it appears
Have
that
you
it is
moved it?
pending as of today.
No, have you moved it? Have, sir, you
But
know
how-
better, sir. Sir, you know better.
My lord, that is
Sir, you are-
pending hearing. Kindly, my lord, I may be wrong, my lord, subject to correction.
No, sir, you
Kindly
are,
look at
sir,
the last
you are a senior
annexure.
person, you know better, sir. One has to move the application. I can file it.
I have
Certain from your client, sir, certain from your client,
My lord.
two things. Sir, you may do this. You may file an application
My lord.
very well
my lord.
and forget it.
No,
Correct? No. I'm saying it may not happen.
my lord, it is fixed for hearing from time to time.
After filing the application,
I
the
have
application has
moved
to be
it.
moved.
I have moved
It
it.
is the order
My
sheet.
lord, kindly look
No.
at the last information slip.
That will not. Order sheet have show me.
My lord, the information slip says, my lord, it is fixed for hearing.
You bring it tomorrow, order sheet, that you have moved it. It will reflect in the order sheet.
My
That
lord,
this application
that
was
is
moved.
in Barasat court. Now, in that case, kindly keep it for next Monday so that I can
Yes,
get
yes.
the entire order sheet.
দুই সপ্তাহ বাদে?
I can get the but from the information slip, it appears that it is pending hearing. But I have
Sir, you know better.
my lord,
You are a third party,
my lord,
correct?
my lord.
If you file the application and just keep it, the court is not aware. Court knows that application is there.
Yes.
But how is the court bothered? You are
Because-
not moving the
Lord,
application.
I tell you, Lordship,
You
I
have
may,
to
may-
move it.
my Lord, subject to correction, may I? Lord, when I moved the application,
Sir,
bank
come
was
after 2
directed to
weeks.
file written objection. Bank has filed the written objection.
So
That is on
will be
record
reflected. That will be reflected in
in the order sheet, the entire order sheet.
No, that particular order will show. Now it is all on the net, sir. Everything is on the net. No, 2 weeks is not necessary. I do not know for what.
But from Bharasat, it has to be applied for and obtain the entire order sheet.
To my knowledge, sir, by sitting in this court, sir, if you use your telephone, sir, you can from your mobile
But
phone.
kindly
you
keep it
can
for
get
next
sir.
Monday.
Yes.
Kindly keep it for next Monday. I shall bring the entire order sheet.
Don't tell me
For your
e-courts is
lordship's
available, sir.
satisfaction.
If the order sheet is there, it will be available in the e-court system, sir.
The entire order sheet I have to
Not
obtain.
necessary. That
particular
particular
order.
order you moved it. Show me you moved it. Show me you
Yes,
moved
I
it.
get
That's
your
all.
lordship. I get your lordship.
It is pending. It will appear from that document. But you moved it. An order was passed. Otherwise, if you keep it and you want the court to direct the learned judge to hear it
Yes,
out without
but,
moving it.
uh,
Sir, you must be fair to the
yes,
learned
yes, yes,
judge
yes.
also.
But I need to take
You must-
necessary instruction
Correct.
from my advocate on record in Bharasat.
Yes.
From Bharasat. Kindly keep it for next Monday. Lord, I shall come. I shall
Monday week. Yeah, the
Monday week, as you Lord.
Yes, order
I shall take the entire order.
হবে না একাই থাকবে
My lord.
ডাকো
45, but I'm looking for the petitioner late.
Yes.
Mr. Mola, I thought, well, this is a revisional application, is against the order of the learned trial court, whereby the order 9 rule 13 application was allowed and the ex parte decree was set aside.
Very well. What is the wrong in the order?
Well, it kindly come to
No,
page
what is the wrong in the order? You tell me.
that the summon was served upon the defendant. They refused to accept it. And
No, on what ground this was allowed?
uh,
Where is the order? Impute?
order is at page 76 onwards.
Cost you have received? You have received
Cost,
the
they have not paid the cost till today. They have refused to accept. It is reflected in the order sheet as well as in the cross-examination of the process server. He stated that the defendant refused to accept the summons. And the postal track report also says that item delivered. Well, it once come in page 27.
So summons was served on 12th of August 2016. Admittedly served. It was a Friday. So since he was not supposed to be there, that is why the court said, what the court said?
Well, kindly come to page 27, typed copy of the order sheet. Page 27. They had full knowledge.
How was the summons served?
Well, kindly come to page 27 first, typed copy
No,
of
no, you tell me, sir, how was the summons served?
by post and also process server. And process server in his cross-examination said, I have gone to the resident of the defendant. he refused to accept.
And so far as the postal,
Postal report, item delivered. Well, kindly come to page 27 first.
challenging
Typed copy of the order.
suit for
Suit for recovery of khas position and mean profit.
eh?
Recovery of khas position, damage and mean profit.
tenancy.
Tenancy.
Challenging
Twenty-second November 2023.
August.
Well, my lord, kindly consider, my lord. My lord, kindly consider, my lord. And the compromise between the plaintiffs and the defendants were going on to settle the dispute. That failed. I have also stated in paragraph 7. My lord, kindly consider.
Application for certified copy you made on 11th of October.
No.
Yes.
Initially, he was trusted the job. He misguided us and also the plaintiff. He did not collect the certified copy. Thereafter, puja vacation started last year. After that, we applied.
Sorry, when did puja vacation start last year? Yes.
Probably
11th of October, you have applied for certified copy.
yes. He did not apply initially, my lord. I can also show you from the my.
No, showing will not do, sir. And you are not the plaintiff, sir.
I am the plaintiff, my lord.
You are personally not the plaintiff. So therefore, from your
No, no,
telephone, nothing will appear.
My lord, we enter the job to the learned clerk also, my lord. We have to.
Who is the learned clerk, sir? Sir,
Clerk.
who is the learned clerk?
Clerk.
I want to know.
Sorry.
Who is the learned clerk? It has been written here. I fail to understand, sir.
Sorry.
What is this going on?
Sorry, my lord. My lord, kindly consider my critic. I am tendering my unconditional apology. My lord, kindly.
You correct the petition, sir. What is this going on? Started addressing clerks as learned clerks.
Sorry, my lord.
This is something which is reserved for advocates. And what is the name of the clerk who was looking after this?
I have not written. Shovik, Mr. Shovik. Shovik.
Have you lodged an FIR?
Sorry.
This is an offense if you, according to you, misleading someone, if it is correct at all.
No, it is correct. My lord,
I'm not very happy with your, sorry, sir.
sorry, my lord. I am tendering my unconditional apology, my lord. My lord, let me serve. Let me serve and come back.
Very well. Challenging Mostly.
Much obliged.
আরে ডিসেম্বরে করে দাও, রাখা থাক, ডিসেম্বরে দেখা যাবে। The petitioner is directed to sir file affidavit of service on or before the matter is taken up next. 700?
It's for my wife's benefit. For my wife's benefit, my lord. What was the
Petitioner. It is a case of PM son, my lord. PM son case. Yes, my lord. Section 89, my lord, he filed, my lord.
Well, the PMSN case has been allowed by the junior judge civil. Then, my lord, the paper appeal, PMT, that appeal, trial court order already said aside. Against that, I have come before your lordship by the district judge. On the ground, my lord, relying the Barasat Eye Hospital case, my lord. Well, matter is pending before the special bench, my lord. The order, my lord, first, page 43, special bench. My lord, your lordship kindly pass the order and leave. My lord, when the matter is pending before the special bench, how can I, my lord, get the order? Oh, yes, yes, my lord, yes, I shall not. Yes, I shall. Yes, I shall. Yes. Sorry, my lord. Monday. Yes. Date will tell.
I'm for the opposite party. For the 9920 in item number 51. 50. Opposite. I'm grateful. Indeed. কেবিট ছিল না। No, I'm grateful.
52, my lord. This is an application for expeditious disposal of a suit which was filed in the year 2008, your lordship. Yes, and it is today, it is at the stage of examination of the defense, examination of the defense, your honor. What I can see, evidence of the defense witness from the e-court website, I can see it is fixed for evidence of the defense witness. My lord, I'm just praying. Yes, Your Honor, I have taken note from January till today, Your Honor. It is for evidence. It is from the e-court website and from the Your Honor, kindly dispose it of, Your Honor. My lord, kindly keeps it. I can bring it weeks later. I can bring it and show that they are taking adjournments on this Monday, my lord. Monday week, 18th. My lord, I will bring from the website, my lord. They are taking, my plea was that they are taking it. My lord, I will, my lord. I'm grateful. What did I do record for it?
My lord, item number 53, my lord. Lordship, kindly, my lord, I was running from court number 18. A matter was going on, item number 3.
To the opposite party. On behalf of petitioner paying for not to. My lord, let their suit, my lord. But the order was complied with. The order which has been challenged after 6 months, it was complied with. Practical.
56.
55.
So, no, Lord, I appeal for the petitioner. Lord, petitioner is the landlord in a suit for eviction. Filed, my lord, defendant, without filing counter claim, my lord, challenged my ownership of the landlord. He said in his written statement, he said that I inducted him, but my lord, stage is at the stage of evidence. My lord, he filed an application under order 26/9 for elucidating whether the property situates in a PWD land. Commission. My lord, he has to state in his written statement by filing a counter claim that this property is situated under PWD because he is a tenant under me. In the written statement, he's admitted that I inducted him as a tenant. within the PWD land. His statement is that, well, the application is at page 25. He's challenging my title, attempting, without my lord filing any counterclaim. Attempting to challenge. But page 25. But the points for local inspection is at page 26. Well, to ascertain and fix in the locality of the suit land as described in the schedule of the plaint, whether the portion of the point number 2, whether the portion of the land and structure is occupied by the defendant from the scheduled property of the plaint, from the scheduled property of the plaint, my lord. So, what is the area of the land and point 1, my lord, no difficulty to ascertain the land. Point number 3, whether the said shop room of the defendant is situated on the roadside land of PWD or over the land of the plaintiff at plot number 2250. My suit based on plot number 2250. Now, my lord, whether the commissioner can ascertain whether the land falls under PWD. That can't under it. I'll serve and come. Entirely allowed. Yes. There is no basis because he, first of all, my lord, my lord. My lord. There is no basis, my lord. My lord, written statement I have annexed. My lord, page 10 onwards. My lord. That the room in which the defendant is running business is not the suit plot, but is situated on the roadside belonging to the public works. Yes, yes, but my lord, their case is that I have inducted them. Their case is that I have inducted them in the suit plot, but they found that the suit plot is in PWD. They have to file a counter claim to that effect. Because my lord, as per evidence act, my lord, they cannot challenge my lord ownership. A landlord cannot challenge my ownership. My lord, order impute, my lord, the certified copy is the last portion, my lord. Order number. My lord, Srivijay Dunajo's first court. My lord, they will go for the commission, then my lord, their petition will be infructuous. My, I'm grateful. My, I'm grateful. Grateful.
My lord, 58, I appear for the petitioner. Petitioner is the plaintiff decree holder. My lord, unfortunate the situation is the decree was passed in 1987. My lord, the petitioner decree holder subsequently filed an ejectment eviction suit. It's a result of eviction suit for eviction, my lord. Obtained the decree in 86. My lord filed a eject execution case. My lord, it has been pending since 1987, my lord. Subsequently, the other side came up with an appeal, which was dismissed by this honorable court in 2010. My lord, thereafter, that party never participated either before the in the execution case nor before this honorable court. My lord, it has thereafter the record went missing. We applied before the court below to reconstruct. My lord, it has been pending long since. Subsequently, this year, few months back, what the after the new bench and the new judge came in, my lord, the records were reconstructed, my lord, and the bailiff notice was again issued. It is the present stage of the suit, my lord. All I can seek, my lord, today is for an expeditious disposal of the execution case, at least, my lord. Because that is the scenario of this, my lord. If my lord kindly goes to uh, the order sheet, my lord will find that the lower court below, my lord will find it attached, my lord. The lower trial, the execution court, what has been doing is, my lord, it has been asking for report from the registrar on every subsequent date, and the registrar of the lower court has not been was not filing the reports. It has been the stage has been like this till March 2024, my lord. Pending for report, my lord. Now, the presence, I don't have the order sheets here, my lord, but as per instructions, the records has been reconstructed finally, my lord. And the execution case is proceeding, my lord. But my lord, kindly consider it's a 1987 execution case. For the report, it has been lying like that since the next date was 23rd February, 3rd February. My lord, the report has been filed and the reconstruction has been done finally, my lord. My lord, that order copy I do not have. If my lord guidance gives me time, then I can come up with the. My lord, when this application was filed, it was at that moment. My, My lord. I shall come. I shall come. My lord, my lord, you can come up with the orders. Yes. Monday week. Yes, my lord. Grateful, my lord. My lord, only. Yes, my lord. That is the situation, my lord. I'm grateful, my lord. Grateful.
But I'm sorry, my lord, 53, my lord, I could not reach. I was in. No,
I'm for
53.
Lordship.
I'm sorry to disturb you, Lord.
Lordship, a suit for partition and injunction was filed against me. I'm the petitioner. Thereafter, a ex parte order was obtained by the opposite party number 1 and 2. Suit for partition and injunction was filed against me. Yes. Ex parte order of was issued in their favor. Yes. Injunction of status quo. And thereafter, I have filed Order 39 Rule 4 application for modification of the order. But I want to, I have made that application on 21st for modification of the status quo order because I cannot construct a building over there. Some of the co-sharers have sold their share to the opposite parties. Lordship, I want a early disposal of my application which is pending. A modification application. No, Lordship, expecting. And subsequently, it was extended time to time from 2022, Lordship. Lordship, kindly come. Lordship. No final order was passed. Ad interim order was time to time extended. I want modification of the. Yes, Lordship. Yes, written objection I have filed. Lordship, kindly come page 22 once. On 15th February 2021, plaintiffs here, opposite party number 1 and 2, moved the petition under Order 39 Rule 1 and 2 for ad interim injunction. No, Lordship, this is not HON'BLE. They have purchased a portion from my co-sharer. Yes. I'm going to construct a building. Yes. They are in possession. They have purchased and thereafter they made an application for partition by meets and bound. Thereafter they got a order ex parte. Subsequently, I have filed an application under Order for 39 Rule 4. It was not heard. Yes, Lordship. Stranger purchases. Yes. Status quo order. And for that reason, I could not construct my building portion. And thereafter, on 2021, April 2021, I have filed an Order 39 Rule 4 application. That was not heard till date. Yes, Lordship. Early disposal. Yes. Since it was a 15 to 2021. Twenty-five or 20. Opposite, but it's both way, Lordship.
Both ways. Both ways.
I have annexed Lordship order dated this till December 2023. Thereafter, I will annex. And service by both way. Yes, Lordship. Obliged, Lordship. Season's greetings, Lordship. Much obliged, much. 19th. On instruction, I am saying.
My lord, in this matter, Mr. Sani Nandi appearing for the petition, he is not come to the court. Kindly, my lord, not today. Item number 61, my lord. 60. 61. 61, same.
I'm the plaintiff petitioner. My lord, this is, my lord, I'm praying for, my lord, expeditious hearing of a partition suit which was instituted in the year 2008. My lord, kindly comes to 8. Kindly comes to page 81. Kindly comes to page 81. The relevant portion is at page 82. Plaintiff. Page 4.
ওই লাস্ট
Yes, yes.
এইটাই
Yes.
বলছি আমরা ছিলাম না ওয়ান ডে অনলি
Only one day. Only one day. Only one day. Yes, I. No, because I need not. Because kindly see, PO was on leave, 18th August. I should not, Milord, be present, Milord, only for filing of Hajira. That is technical. PO was on leave. Not today, your lordship is not there. Why should we come to court? Nothing. Ex parte hearing. That is also not proceeding. Well, the expeditious hearing, Milord, we do not serve copies. No, never. Only in matrimonial cases, Justice Basu used to say that I will direct expeditious when husbands come, but provided I will give a chance to the wife to serve, and I will hear whether any amount of maintenance is due or not for that service. Otherwise, nothing in matrimonial matters. I will talk to the learned advocate in the trial court. Yes, 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 yes. Then Miller kindly takes it up on Thursday. Monday, Miller. Very well. I'll try to take up the subsequent certified copies in the meantime.
I'm paying for a transfer of the merits of Parashat to Bardhaman. The only count, and for the white, the only count is the distance count. The lordship, Puro Bardhaman, your lordship. I decided that my parental house in Puro Bardhaman is little limited up with men's degree from your lordship 2016. It was filed in 2020 in Parashat by the husband. Matrimonial home, your lordship, Parashat 2015, I was married to your lordship. Thereafter, I left the matrimonial home and started residing at the parental house in 2016. Yes, your lordship, 125 is pending in Puro Bardhaman. Now pending for the JM 5 for Puro Bardhaman. Only ground is a distance time, your lordship, takes more than 6 hours one way. Diagram number 6, your lordship. Kindly consider your lordship. What your lordship? I am deciding there, your lordship. I cannot attend there, your lordship, because of it. No, not. Kindly consider it. Otherwise, it will proceed. Kindly consider. It will be considered, your lordship. Ex-party hearing will be very fixed. It has been filed, your lordship, but because of the distance, I cannot attend, your lordship. No, your lordship, till date, because of the distance, I cannot attend, your lordship. No, no. Your lordship, admitting the application, well, kindly pass an order of stay. Otherwise, well, ex-party date has been fixed. Well, kindly, sir.
From that stage, it will transfer. Order is stage. So I do not see it all clear at present.
Yes, yes. But in that event, now at this stage also I have to face the convenience. Well, that is why section 24, lordship. My lord is fixing that January 2020. December. Very. Yes, yes.
Separate.
64.
Not the answer that I am the defendant in a partition. 25 injunction. 25 injunction. And 4 grant injunction. Then what I file order 39 4 package. And vacating I filed for vacating the injunction. The expert, right? Yes. Then I filed, and I filed written objection. But the court, your lordship, kindly see the order. Partitions would have been. Nowadays, your lordship kindly see the implement. 15 July 2020. July. 15 July. Task force.
Now, Lord, dear Lord. Yes, now, Lord, dear Lord, so kindly see. There, Lord, it is. Lord, this application filed not on 15 June 2000. Now, Lord, dear Lord, so that is. Packeting blood, I don't blood, I blood. Yes, it's a blood delay, but not admittedly it is delayed. But blood, this is on record. Objection. Your Lordship, kindly see. Paragraph plus it is also visible. Plus it is also visible. Dear Lordship, it is also visible that the OP have admittedly filed the written objection on 15 June 2020. Yes, but yes. That was, but it is only on injunction application. Mistake. Dear Lordship, stop. Mistake 15 of 2007. That is injunction application. Only injunction application. But in journey blood injunction application is separate mistakes. Suit, then when we file the injunction application, there is a no injunction application separate. Separate bits. Yes, mistakes is there. And no, but that is mistakes in 1570. That is order 13 rule. Now, yes. Now, miscase not dismissed and blood ex party date of hearing fixed by the court. Blood the court not accepting my also the written objection of the injunction application. Your Lordship, can you see it is also visible that the OP have admittedly filed written objection on 15 June 2022. That is on record. Yes, that is this case is gone. But not then not fix ex parte date of hearing. The ex parte date of hearing of the injunction application. That is gone. But not court fix ex parte date of hearing of injunction application. Though my application, my opposition is on record. Yes. Here, logically, it is also, it is also visible that the OP have admittedly filed the written objection on 15 June 2022. Here, logically, see. That is the difference. That is the different chapter. Now, Lord Lordship kindly take up injunction. Yes. It should be, should. Yes. Yes, right. No, that is why I came before your lordship. Your lordship kindly see the order. Lordship kindly read the again. Blood I am reading. It is also visible that the OP have admittedly filed the written objection on 15 June 2022. Yes. And that of a petition for vacating the aforesaid order of ex parte on 18th March 2023 in its court. Not only this, it transferred to the utter surprise of this court that there is no prayer for acceptance of written. No, that is the only thing. I have not filed prayer for written objection. Only one. No.
This is my objection.
Objection. Yes, but yeah, but I filed the written objection. My acceptance, my written objection will go. That is not written. Your lordship can see. Acceptance of written objection even. Needless to say, the act and conduct of the OPs make it perfectly up to this court, not only about their dilatory practice implemented since their appearance in the year 2018, but also taking a court of law as granted. Only thing is not, I filed the written objection admittedly. Admittedly, I filed the written objection in the next step. No. The state that is pending thing. That's right. Then I have to take inside. Yes. In the month of February, yes, take things. That is not your lordship. All things your lordship are asking. Your lordship are all things asking. That is not your lordship. Lordship can't take it up. Favorite. Lordship in the month of February. Month. But then we take a photograph. But certified copy will not get. In a short period, for certified will not. That we can. Yes, right. Your lordship. Yes. Then my lordship can take it up Monday. I will. Yes. Yes, I will. Yes. Yes. I will. Yes. Yes.
66. Order number 66. '67.
I appear for respondent number
67.
for 67 lordship. I appear for respondent number 2. I appear for respondent number 2 lordship, but I have not. No lordship. Most probably it's not there lordship. I have not been sent. It's appearing for the first.
Not today, my lord. I'm just informed by
Lordship, I'm just praying for service of the copy first, lordship. It's appearing for the first one.
Yes.
Lordship,
I'm not the advocate record. my lord.
lordship, I'll tell you, lordship, may I indicate? Let the direction be there for sir.
I'm good with that.
Much obliged, lordship. This. Response number 2. Seema Das. Seema Das, respondent number 2. Siddhartha Roy. Correct number? Lordship, we will file it by the course of the day, Lordship. 2. Definite. Definite. Much of. Much of. Course of the day, Lordship.
I am.
My lord, I have been instructed to. I have been instructed to appear on behalf of the opposite party, my lord. If your lordship kindly direct. But no copy has been served, my lord.
My matter will be appear next month.
Kindly direct them to serve me.
Matter relating to the execution case, 97 file, police has rejected, challenging that order. In the execution case, they have filed an application for police has the application allowed and challenging that order, madam. Seven allowed, challenging that order. I am for the judgment. I am for the judgment.
Kindly record, my lord. Then they shall not pray any adjournment before the learned trial court.
Judgment. Judgment date or appeal, second appeal already pending before this court, not yet been admitted, but pending. Kindly not one. My lord, in the my lord, kindly not. My lord, my feet not. My lord, I am my deep not but accessible when I am accommodation this week, my lord. Next week. Next week, my lord. My lord, deep not accessible. That's why I am interested. My lord, deep not accessible. My lord, kind next week, so Monday I will do it, my lord. My brief, if is not traceable, not traceable. What is my second appeal pending before this one? Second appeal has to be admitted. Not admitted, but yes. No admission. I have one time. One thing. One time came up for hearing before the honorable justice. Thereafter, my lord, thereafter case.
My lord, tomorrow I have some personal difficulties. Day after tomorrow, my lord. Tomorrow I shall not be able to.
Time next week, Monday, I am not available. Monday.
Monday.
I'm good. Second appeal already one time appeared. Thereafter, one order has been passed by the division. Thereafter not appear before this division. Not appear. Not I have mentioned size, my lord. No. Not admission.
That's why, my lord, I am challenging that order, my lord, the matter is pending before the order. Yes. If my, if the order, degree has been executed, then our second appeal has been effectuous. I have filed objection in colors. Yes. Evidence not taken up. Yes. I'm getting.
69. For the petitioner, my lord, rejection of amendment application at appellate stage. I'm the plaintiff. My suit for, mistakes are detected, my lord. Mistakes and very, my lord, minor mistakes, my lord, in the plaint. But one not major, but one change is, my lord, the constitution of the family for reasonable requirement. Some family members found there is appellate stage, so you are trying to delay the matter. But my own suit, why should I delay? I am the plaintiff, I am the landlord. Reasonable requirement, my suit is dismissed. Family members, at any stage I can take up, my lord. Yes. After the appellate stage also I cannot bring up, if there's a change in constitution, even in appellate stage also I can bring up. There are some judgments to that effect also. Today I am not armed with those judgments. Only the schedule of amendment is at page 41. Kindly similar, very, very minor in nature. Page 41, bottom. Let them come, very minor amendments. Only the constitution I have not specifically stated. These are the family. It's not at the appellate stage also I can take up the issue of family members. If there is a change, current position is to my appeal. So why should I delay? What I said, appellate stage, you are applying, and no, one more defense has been taken that de novo evidence has to be taken. But for giving the name of the family members, de novo evidence is not required. No evidence has been necessary. That is the main ground. They say that de novo trial is required. But de novo trial, I'll only rely on the documents produced. As a motion. Yes, reasonable motion. Any date, very short point is involved. Right? December, instead of monthly, any date, December. Fine, fine. Fine. huge pendants, civil division. So many matters. Number of matters is very huge. So then, okay.
Before the petition. Alimony, or inadequacy of the amount. I am the wife. Matrimonial suit filed by the husband. Husband is a manager of NABARD, but presently posted at Madhya Pradesh. He is earning near about 1,70,000. Alimony, my lord, ordered 15,000 only. But I should tell you this, your lordship. Yes, both party filed their affidavit of assets, and as per the affidavit of assets filed by the husband, he is presently posted at MP. He is a manager of NABARD, but page number 118 is his statement. 118. His gross income is around 1,49,000, and parking fees and other benefits are around. But now, my lord, if he is deducting, my lord, contributory provident fund, my lord, that will not be counted, my lord. My lord, only the gross income. Contributory provident fund will be deducted as per my volition, as per the volition of the employee. My lord, in order to, my lord, avoid maintenance.
Now, if you are the gap, also you cannot go beyond that gap.
My lord,
Ascertain whether you can go beyond that gap or not. So, 1,30,000 gross income.
95,000. He is getting his monthly expenses 95,000. Ordered, my lord, 15,000 per month.
How many cases are filing?
My lord, 125 is pending. There, my lord, he is paying that there is an order to pay 10,000 per month. Apart from that, my lord, 15,000. If the both is amalgamated, then also, my lord, it does not come on, my lord, within the purview of, my lord, Neha versus Rajesh, my lord, that will, my lord, 1/5 of the, my lord, income. Judgment, I am not handed over, my lord, handed me. But in the meantime, well, may I serve and come back? My lord, my lord, me. My lord, monthly expenses, my lord, I can, my lord, show, my lord, before the court. I can show, my lord, many ways. My lord, there are many ways to show, my lord, before the court, to avoid maintenance. Matrimonial. He is not paying. 15,000 has been ordered. That, my lord, I am telling you. No, I am challenging the amount. The amount. The amount. No,
Sir, can I
no.
As a lecturer,
No, as it prima facie appears, on his admission, my next my
71.
I beg to appear on behalf of the respondent, my lord.
This is against an order, my lord, rejecting application under order 122 of the Code of Civil. My lord, the plaintiff is a religious organization, my lord. Purpose is for displaying, my lord, devotional and classical songs and to provide education. Now, my lord, the defendant was his secretary at one point of time, my lord. He was misappropriating the fund. My lord, this is a case of the plaintiff, my lord. That is why, my lord, a general body meeting was called, my lord, and he was expelled from the membership, my lord. My lord, the plaintiff is being represented by the present secretary, my lord. Now, my lord, no, my lord, that is in respect to another person's, my lord.
secretary, president, and treasurer file their application, my lord, that has been rejected. And my lord, subsequently, my lord, it is a case of the plaintiff that this defendant, my lord, has misappropriated the funds of the organization from Punjab and National Bank, my lord. From Punjab National, where the account of the organization is lying, my lord. And my lord, that is why, my lord, this petition has been filed 10-2, my lord, for adding Punjab National Bank as party to the suit, my lord. But that application is that is the contention of the plaintiff, my lord, in the application and order. My lord, I have served, my lord, though they have not lost caveat, my lord, I have served, my lord. No, but my lord, but 90 have been served with the copy. No, but I have something. Used to be a corona. 90. Yes, but they are not the party. We have preferred the application. I am the respondent. Defendant, my lord. They are not the. They are not the. Yes. Why are you objecting? I'm not trying to get order. My lord, in this revisional application, Punjab, my lord, that I cannot say right now. Yes, my lord. My lord, that is an annexure C, my lord. Annexure C, page 21. But this is only order sheet, my lord. That is the impugned order, which is challenged before your lordship. Well, that is one previous application, well, that was rejected, filed by the secretary, treasurer, and president of the association, well, that was rejected. For adding. Well, that was rejected. And well, the subsequent. The actual part. Kindly get the order passed with regard to previous application where they declare challenge. Yes. How can I decide present petitioner might not, they are not the party. The organization is the petitioner before your lords. Madam, that is order 1, rule 10, madam, read with order 6. Madam, that is subject to correction, madam, that I super. Yes, madam, that was dismissed. My lord, it is a specific case of the plaintiff, my lord, that this particular defendant, my lord, has been misappropriating the funds of the bank through the bank. My lord, that is also my case, my lord. That is also my case. My lord, your lordship.
Actually, my lord, past order 26, they did not, just because we might be deviate, they did not prefer any department, my lord.
My lord, day after tomorrow, my lord. 14th. Grateful, my lord.
For eviction of license. But let the payment on the let the payment let us no, this has not become infractious, but basically, below the counterclaim they want to assert. Very well, very well. But I am on caveat. Mukherjee. Opposite party, sole opposite party, plaintiff opposite. Good. Good.
Seventy-three.
Yes.
Seventy-four.
I refer to the petitioner, my lord.
I have instruction to appear for the opposite party.
Repairing application has been rejected, my lord. Suit for eviction. Suit for eviction. On the and for the defendant. Application for repairing has been rejected, my lord. On the ground, my lord, that the trial court could not find by the
clear picture of the suit property. Although, my lord, I had annexed the photocopies of the photographs of the suit premises, but the application is at page, my lord, page 22. Schedule at page 25.
Opposite party plaintiff.
Man, yes.
75.
Rejectment suit is pending before the trial court, my lord. I am the defendant in that suit, my lord. My lord, the then advocate appearing before the trial court, my lord, he did not know the provision of the West Bengal Premises Tenancy Act, my lord. Okay. My lord, the Biden advocate who was appearing in the trial court, my lord, he did not know the provision of the West Bengal Premises Tenancy Act, my lord. I mean, even, my lord, he did not appear before the court on the fixed date, my lord, and the petitioners were not known to all these things, my lord. And due to which, my lord, the so-called notice was issued, and on that date he did not appear. So that, my lord, the ex parte hearing date was fixed. On that date, the petitioner came to know. No, my lord, because he did not inform the petitioner. Petitioners has no knowledge about the provision of West Bengal time. No, my lord. On that ex parte hearing, where we have on that the ex parte hearing date, another advocate appointed by the petitioners, and he appeared before the court, and he filed the reply of the so-called notice, and for the vacating the ex parte hearing, and he also filed the section 7(2) application. But it was rejected by the trial court, and the trial court passed an order to contest the suit by depositing the fine of rupees 5,000. And my lord, by challenging that order, we the petitioner also filed the revisional application before this court. And my lord, come to the case page 32, my lord. The order of this Honorable High Court. Yes, ma'am. File and application. File and application. My lord.
যত অব্দি হবে আবার এটা উল্টে যাবে
My lord, in item number 76, my lord, Mr. Trivedi is appearing, your lordship. He has just informed me, my lord, he's on his legs before another courtroom, my lord. If it can be taken up tomorrow, your lordship. Much obliged, lordship.
Seven. 77.
It's not I am appealing for the prisoner, my lord. In this matter, my lord, caveat was filed, my lord, I sub-copy me upon Mr. Varun Bandyopadhyay on 18th March 2024. My lord, the opposite party, my lord, filed a suit that was dismissed. Yes, my lord, on 18 March. No evidence, my lord, upon the caveator, learned advocate of the caveator. That is, he endorsed on my application, my lord. No, that is should not be done, but in general, sometimes it is done that. Yes.
77, my lord.
The opposite party filed a suit, my lord. That was dismissed for default. And there was a restoration application was filed after a delay. When the this miscase, the restoration application was for at the stage of evidence, my lord, she sent her husband to depose on her behalf by making an application with a power of attorney. And the same was rejected. That is order at page suit for declaration and injunction.
But only one question is involved, Lord, whether a civil judge can alter his order, past ones can alter his order in the subsequent. This is the main question. No, Lord, typographical mistake or my error on the face of record can be altered, but total order has been altered. That is first order, Lord, that is page 53, relevant page. Order dated 15/9/2023, order number 183. My Lord, may I read, my Lord? My Lord, the today is fixed for hearing of the petition filed by the petition under section 151 CPC. Both parties filed hajira, heard both sides, peruse the material on record, consider. The present situation is that original petitioner examined herself as PW1 in part. Thereafter, she could not produce on produced on doc, despite her order, despite the order of the Honorable Court, Calcutta. She had been given several occasions, but she could not be present, and ultimately her evidence was expunged. Thereafter, the matter has been fixed for OPW. The contention of the petitioner is that husband of the petitioner be allowed to adduce evidence instead of the petitioner by filing a power of attorney. This case has been excluded by the petitioner to satisfy the dismissal for default, and she had filed an application under Section 5 of the Limitation Act 1963 for condonation of delay in filing the instant quit to set aside the same. Hence, the reasons or the grounds that the petitioner seeks to furnish the adduced evidence to the extent is personal to the petitioner herself. She has to state circumstances to show that there was no intentional latches on the part which prevented her from taking steps in the suit which was dismissed. Hence, her husband cannot be deposed on her behalf to state her circumstances which impeded in her original title suit. He cannot depose to show that there was no intentional latches on her behalf. The circumstances to be personal. Her husband cannot be deemed to know the same in any manner. He cannot step into the shoes of his wife in his case. Considering this petition of the petitioner is hereby rejected. This is the first order. Then, my lord, by the impugned order, he allowed this. The learned civil judge allowed this. Order 22, Rule 3, my lord, this. Order 22, Rule 3. Order 22, Rule 3, my lord. Once order was passed, my lord, that cannot be signed. Order 20. 120 evidence. 22, 3, এই তো order 22. সেটাও এভিডেন্স একটা amendment to add the name of the husband of the petitioner, my lord, and to allow him to depose. No, no, no. The husband of the opposite party number one, plaintiff opposite party number. Yes. Plaintiff opposite party. No, there is no, there is provision in several High Court parts order. Husband or wife, spouse can give evidence, but yes, the spouse can. No, no, my lord. Wife can depose, husband can. My lord, first this was rejected. That is on 15 September 2023. This rejected by the civil judge that husband will not be allowed to adduce evidence. Subsequently, virtually the order has been altered and allowed. Copy has not been added, my lord, then I shall produce it. I shall produce the copy. No, no, I shall file by supplementary, or show your lordship. My lord, due to my lord, urgency was filed, my lord, I shall produce the copy next day. Not at present. I shall produce, my lord. Kindly, any day, my lord, your lordship. No, my lord, at present. One early date, my lord. My lord, under circumstances, is could not. No, no, no. That cannot be done. Blood. December, month list of this.
$56 one.
My job.
58, 56.
May I be permitted to mention?
Don't mention now. Yes, call the list.
Law is, according to my humble reading, that if a person dies after executing a will prior to probate, the executor, the property vested to execute. If this is the law, if I'm stating correctly, then my lord, in a suit for passive performance in respect of that property, the executor is necessary. The executor is necessary. Yet my application has been rejected for addition of party on the ground that 213 of Succession Act does not permit unless the property is granted, ignoring 211.
Decree it is decree. It is a question of grant of decree. No decree can be passed.
That will come later.
Yes.
The moment the person
একটা এ দাও তো সাকসেশন অ্যাক্ট দাও তো
আছে,
হ্যাঁ আছে আছে হিন্দু নয় ইন্ডিয়ান সাকসেশন অ্যাক্ট হিন্দু কোথা থেকে পাচ্ছ আচ্ছা দাও
না থাকতো, করছিল।
আনাও আনাও ইন্ডিয়ান সাকসেশন অ্যাক্ট আনাও ইয়েস
And see 211.
200 property vests.
Property based.
That is all right.
Somebody has to look after it.
Yes, the executor from the very first day looks after the property.
That's all. I have as an executor, I have applied for addition of party in a suit for passive performance in respect of that property against a person who died during the pendency of the suit by executor.
And here it has been rejected.
My application will reject.
By relying on
213. There is no manner.
just sir, you are ready with the provision, sir. Let me go through, sir. I am not that ready, sir.
That's supposed to. I have read the brief. My lord has not read the brief. That's the distinction.
You have attempted to apply.
The moment
You have applied. Who has applied?
May I indicate? Repeat.
Huh.
The suit for passive performance is pending against the person for whom I have become the executor after granting of property.
Correct.
He is no more. She is no more there.
Yes, the suit will fail. How are you concerned? How are you bothered?
How suit can fail?
Because if the person has already died according to you.
Joint property. One is there. 3 persons was there. One share vested to me.
Yes.
He was the executor and the beneficiary also. I'm not saying beneficiary because probate has not been granted. So executor is now to protect the property. But one yard is also already there on record. So suit cannot fail. I have to protect the property of the deceased.
What is the order?
Order is, my lord, many things has been said. Those are, according to me, is not irrelevant.
No. Just short order. Let me go through the order.
Right. Due to section. একদম পাঠালো আরেকজন আর্টিস্ট ওই আরেকজন আর্টিস্ট তুমি একজন আর্টিস্ট কয়জন আর্টিস্ট অল ফিল্ডে আছে কোনটাই নেই
The interest is not denied.
No. Because my predecessor was party. Property belongs to her.
Actually, 78.
First consider 11, then go to 13.
No, I'm not on that.
Wait, wait.
I'm just considering section I've forgotten. 78, yes. 278 is the letters of administration and administrative pendentitis. I'm just going to that section. Which section is that, Mr.?
Tell it instantly. Administrative pendentiality has to apply. That property is being wasted. 11 said the moment the executor died, the testator died, it vests to the executor.
There are certain authorities on this.
Yes, yes.
On this, whether
We have cited.
no, whether on the issue whether, Mr. Vasu, the right to be added as a party in a suit, whether any application is required to be made for an administrator pendentiality for that purpose.
This is not that administrative pendentiality matter at all. Here is a case.
Well, I will hear you. This is a point of law to be heard.
The point is a very simple point. The moment
Wait,
the
wait,
person died,
no caveat.
vests.
No caveat endorsement is there. I'll serve, you serve.
Let the suit be state. Property I have to manage. If I am not party, if the suit decreed, my property will go.
What is the stage of the suit? What is the stage of the suit?
Immediately.
Come back, tell me the stage of the suit tomorrow.
Stay, it's suit. Whatever.
No, no, stay. Injunction application going on, no point, because it is already returnable next monthly list. Thursdays I will take up.
No problem. So suit should not proceed in the meantime.
No, no. Why? If the WS is required to be filed, let them file. I'll grant you opportunity to file WS, if at all, or if you have already filed, because you could not have filed WS. You could not have filed because your predecessor had died.
Then count in the 90
The
days.
testator has died. The testator has died prior to filing of the suit.
Prior to filing, no. During the pendency of the suit, he was party in the suit. He was contesting.
Oh, then you will step into his shoes.
He has not filed any registered.
Then you will only step into his shoes. I'll protect you at that stage. You serve and come. No stay is necessary at this stage. Unless you can tell me, naturally, if you can come and tell me, I'll grant you that leave. Tell me what is the stage. Early stage, no point in staying it, because now these orders really interfere with the hearing of the suit. If the suit can go on, I will hear you on the next date and finish it off.
This is now it comes to our court's practical difficulty. Matter could not
I'll fix it.
matter could not be taken up. That's the problem.
This Thursday, I do not know if it changes. Apart from that, I'll be trying to take up these matters on returnable motions on Thursday.
Have no notice with 2-3 days. How many pending matters are there before my lord?
The infractious.
Infractual.
That is why those are being dismissed.
That's the problem in our court today. At least in civil revision matters. And after the judgment of Justice Ahluwalia, if the stay is not granted in writing, court has to proceed.
Naturally.
So then what we are. Previously, we used to say the court matter is pending in the High Court.
Still you succeed in getting, Mr. Vasu, still you succeed in getting adjournments. That is not an issue. No, let us not go that far. Let us not go that far. Let us not go that far. The present application, revisional application has been filed challenging an order dated 11th of uh, liberty to apply.
I may have to describe your
Liberty to apply. Not necessary. I might take it up.
May not be necessary, but if necessary, my lord.
Because returnable motion, there will be a group.
Today, my lord is not facing problem. Tomorrow it will be accumulated.
Has to accumulate.
So then
No, today what is the difficulty? Today, let's not go into that. Why people are not coming? Let us not go into that.
even if something required from our side, we are here to assist, my lord.
Yes. No, I'm not on that because people are apprehensive. That is why people are not coming. So you understand
That
happens.
My lord knows that.
Yes.
So, jana kotha.
So that is all right.
Some are genuinely missing the list and some are not coming.
No. You know how many matter dismissed?
Yes. Some are coming to mention this matter.
Oh, wow. Negligible, minuscule percent.
Maybe infructuous also.
Yes.
That's the problem.
Orders have been passed last year.
Infructuous.
Yes.
That's the problem with us.
Yes. Yes. Why, madam? When was the suit filed? Yes. Why expeditious? 3 years only down the lane. What has
My
happened?
lord, I'm the defendant in the suit for partition, my lord. Now, my lord, one ad interim injunction was filed by the plaintiff, which was allowed ex parte. Now, my lord, that is continuing. I'm only praying for expeditious disposal of that.
Have you filed written statement?
Yes, my lord.
When did you file written statement, madam?
I have filed written statement on 27th of January 2022.
Learned Advocate Commissioner files report. So it stage suit has moved. Preliminary decree has been passed.
No, my lord.
Then Learned Advocate Commissioner, how does it come in?
That is the difficulty, my lord. Till that ad interim injunction is continuing, and I have not been able to, my lord, I am suffering because of that injunction, my lord. That is
No,
the only-
why suffering, madam? You tell me something which is very important. What is the local inspection? Okay. Order 39, Rule 7.
Yes, my lord.
The injunction application is yet to be disposed of.
Yes,
I'll
ma'am.
direct disposal of the
Yes,
injunction.
only that, my lord. Only that.
Injunction application or both?
My lord, if injunction application, if that is disposal.
What is the only one application file? Order 39, Rule 7, madam.
Yes, Order 39, Rule 1 and 2 filed earlier, then Order 39, Rule 7. And after filing of this suit, they have filed one Order 1, Rule 10 to substitute some heirs. The plaintiff has filed. It was out of time. That is why.
Substitution is going on.
Yes.
Then I cannot pass that order for expeditious disposal.
My lord, for the injunction, just for the injunction, my lord.
Then you serve.
My
Because you see, question of substitution is there. Madam, try and understand. How can he expedite? Everything will be stayed till such time I'll keep it next monthly list. In the meantime, if substitution is complete, you come back. Group 1 next monthly list. Madam, substitution has to be complete. Without the substitution, no order. I'll just place it in the next monthly list. If I pass an order, then we'll go back. Just makes number group. Once bring the order sheet and the substitution is complete, then I'll issue a direction. Without the substitution, no question of proceeding with the matter.
My lord, I was just praying for.
No, you can't have that. Substitution be completed. These are partition suit.
If one direction for the early hearing of the substitution application, because then my lord, if
When is the date fixed?
Next date is on 25th. Yes, 25th of January. 25th of January, 2025.
Where have you stated that?
My lord,
That the substitution application is pending?
my lord, substitution application, they are filed after filing of this.
File a supplementary affidavit.
My lord, I shall file.
After arguing the matter for some time, the learned advocate representing the petitioner prays for leave to file supplementary affidavit, full stop in view thereof. In view thereof, in view thereof, let this matter stand adjourned and appear in the monthly list of December 2024. Full stop. Supplementary affidavit disclosing the sub.
If you want.
Can you make it not today, my lord? Today, my lord, I'm without leave, my lord.
Continue, sir. Matter is pending for a long time, sir. Your clients are waiting to proceed with the matter. 7th of March, you filed the matter. Yes. What is the matter? Tell me.
Matter, my lord, this is a suit for my lord eviction of a licensee. My lord, I am the defendant, my lord, suppressing the summons of the school, my lord, he obtained, my lord, an ex parte decree. My lord, I took out an application under Order 9, Rule 13 of the Code of Civil Procedure for setting aside the said ex parte decree.
Yes, yes.
My lord, he put the decree into execution. My lord, I took out an application for stay of the execution case till the disposal of my Order 9, Rule 13.
Why?
No, in the meantime, my lord, if the execution proceeds,
let them proceed. Why you ought to have?
My Order 9, Rule 13 would be infectious.
Order 9, Rule 31. Sir,
Ex parte
your Order
decree.
9, Rule 13, if you proceed for 10 years, that is entirely up to you. Prefer an appeal. You prefer an appeal.
No, Order 9, Rule 13 is pending.
Maybe.
No, my lord, by this time, my lord, if the, my lord,
when did you file the application under Order 9, Rule 13?
My lord, just after, my lord.
Yes, tomorrow, come tomorrow, finish it off. Come tomorrow. These matters, sir, will not continue, sir. Not today, huh?
My lord, praying for my lord, expeditious disposal of my lord. Plaintiff, petitioner of the plaintiff of the my lord eviction suit, my lord, filed 28 July of 2023, my lord. And my lord, the
Eviction suit filed when?
28 July 23, my lord.
23. What expeditious disposal? What do you want?
My lord, only thing, my lord, they have appeared on 11th December 2023, the defendants. And my lord, there are 4 dates, my lord, have been passed. My lord, and next date, my lord, 20th December.
Have you taken out an application for filing of affidavit evidence? Have you filed an application for WS has not been filed? What other steps have been taken for placing the matter in ex parte board? What steps have you taken?
But I have to take instruction.
No, tell me now, sir. No instructions. You could file the application for expeditious disposal. If you could file it, sir, tell me now.
Well, may I come back tomorrow with the instruction?
No. You tell me now, sir. No instructions, no.
From the sites, my lord, I have filed, my lord, from the e-court service, my lord, the plaintiff had filed one application for my lord for substitution of the defendant, which has been rejected, and 20th December is the next date for WS, what I find from the internet, my lord.
Here's what happened to your ad interim injunction.
My lord, refused.
Now you want expeditious disposal of the suit. Have you got the injunction application disposed of? Where is your order sheet?
My lord, refused, my lord, on 20 July.
Yes, thereafter.
There are 25th September, the defendants 1 to 7 have been appeared by filing the Wakalatnama.
Yes.
It did not appear.
Matter has been fixed for ex parte board. What happened on 19th of February 2024?
That
For taking steps, what steps have you taken?
for that I need to I have only seen the orders from the internet. I have to take only tomorrow. On 4 dates I have seen from the internet, but no orders are
No, sir,
uploaded.
not like this, sir. Not such slipshod manner, sir.
I've just seen. I'm just
You find out. Tell me now.
only what I find. May I? This is the only this order. May I allow to?
E-code. You find out from the e-code what is there.
My lord, I have found 4 dates have been passed, and this is the last order, my lord.
Tell me, you read it out.
My plaintiff have filed one application for substitution, my lord, under order.
And you want this court to pass an order for expeditious disposal. How unfortunate. Mail that order to my officer. Mail that order here and now. কোর্টে তো ইমেল করা আছে, কোর্টের ইমেলে নেবে। This is not expected. You have even suppressed that fact, that substitution application.
No, my lord. That,
yes, where is your statement in the petition that a substitution application has been filed?
No, that is subsequent.
When has it been filed?
See,
when has the substitution application been filed?
এটা প্রথম এখন দেখছি কবে ফাইল হচ্ছে মাইলর ডিভিশন কি দেবো ফাইল হচ্ছে That is.
Have you seen the order?
My lord. Just I have downloaded, my lord.
You need to take steps against this order. You want expeditious disposal.
I just downloaded.
Just now you are going. Before coming to court, you do not bother to go through the order sheets. What is the development that the court will ask you? Thereafter, you will go through. You will be doing a disservice to your client. Your substitution application has been rejected. Yes, you want to press the application. What is your name?
Devorshi Brahma. Devorshi Brahma.
Mr.
Devorshi Brahma.
Bormon.
Brahma.
Mr. Brahma, learned Sir, you will be doing a disservice to your client if you move this application today. Lako, quarter.
See,
for expedition.
Yes, sir. When this was filed in March. What is the development thereafter?
No, my lord, this is the expedition. This was the execution case in connection with the
Execution case.
Yes. We have filed an application for attachment. That is also execution filed in 20.
When did you file it, sir?
21. 1st October, it will also turn to page 17. At least this should be, my lord, expeditiously disposed of. Your lordship knows. Your lordship has enough experience. Land
Difficulties.
I understand. But my lord, kindly do this at least to hear out.
The land acquisition case.
Okay. Degree has been passed. How much? My lord, kindly turn to page 16.
What attachment did you seek? Survey building?
Bank account.
Bank account?
51,46,000. How long a man will wait, my lord? Kindly see. We have the prayer, hence it is also prayed, landlord court may guess to attach PL account. Then there is no scope of it.
No, this account, whether it is belongs to the government or not, that
Yes,
has,
yes.
how will the court ascertain that?
That is when they know it. Let it be adjudicated. Let it be, application should be handed out. Well, kindly say PL account 8443 of collector not lying in the State Bank of India. Parasat branch. Let the application be disposed of. Either it may be rejected or it may be allowed. It should be at least adjudicated. What your lordship want to, how it will be verified. This is, I know, my lord, they are very much, everybody is aware of this. Or what previously that the DM Bangla would have been attached.
Only bank account attachment.
This, otherwise, it can't. They will be under pressure, direct the treasurer to arrange for funds. Otherwise, there is no way out. So, lordship have enough experience.
No, sir. I am only ascertaining from you, sir.
No.
The present application has been filed. Interiorly, are praying for expeditious disposal of the execution case being land acquisition execution case number 17 of 2020, pending before the Court of the Learned, third additional district judge at Barasat.
Not 24.
Not 24 Parganas. 24 Parganas North. Considering the nature of relief sought for, the present application, considering the nature of relief sought for, the present application is taken up for consideration without service of the revisional application on the opposite parties. Or would I direct service?
No, we shall communicate this order. After disposal, with a
Or would I
copy-
direct service and then dispose it off? No.
No, lordship can dispose of it because it need not be required for their appearance, because for expeditious disposal of the
Yes. The petitioner complains that despite filing, the petitioner complains that despite obtaining a decree in a in LA case, a reference case, decree was passed by in reference
additional district judge in appeal case.
in reference case,
In
not
reference.
appeal, reference case.
Against this appeal is made before the land acquisition collector, that is additional district judge. And
Refer-
they violate.
Where is that order? Where is that order? Facts. Where are the facts indicated?
Well, kindly turn to page 15, 16.
Yes.
Page 15, 16.
Yes.
The decretal dues lying with the State Bank.
No,
of
this is an execution application.
application, yes. There it will receive what your lordship wants to. Under section 8, it is generally award is passed. And
No, thereafter reference case was there.
section 18.
Yes.
And that is to be adjudicated by the additional district judge, who is the
So it
tribunal.
is in connection with the reference case this decree was passed. So that is what I want to know. The petitioner complains that despite obtaining a decree on 6 January 2020 in connection with a land acquisition reference in land acquisition case number in connection with LA case number 01 of 2007 within bracket V, Roman V, arising out of collector's case number LA 4/8 of 2000-01.
Yes.
And despite putting such decree into execution
On 17/12/20, 17 December 2020.
where is the date?
When the date
Putting
filed-
such decree into execution on 17 December 2020, the petitioner has not been able to reap the benefits of the decree,
and also filed an application for attachment.
has not been able to reap the benefits of the decree. Full stop. It is submitted that the application for attachment filed by the petitioner
On
on
1st October
on
2021.
1st October 2021 as appearing at page number 17 of the present application is yet to be disposed of by the learned court.
Although 4 years or 3 years have already.
Full stop. Upon perusal of the order sheet, it would transpire that though the judgment debtor had been filing Hajira
Akoli Chatterjee, I am praying for not today. One of the relatives died. She left the court. Only praying for not today.
Not today.
Deeply.
ভোট দাও না, ভোট আরেকবার দেখো হচ্ছে কি হচ্ছে না। ভোট না হলে কি করে হবে? দেখি হবে হবে, আসছে না যারা, দেখি দাও 85 দেখি, 85 দেখি, এলে তখন রেস্ট করবো।
Order number 85. Fifty-six.
86, I am for the petitioner, my lord. In a suit for declaration and injunction, the defendant is the petitioner before lordship. Declaration, the plaintiff has asked that I am making constructions without sanction plan. Construction without sanction plan, unrelated neighbor. And therefore, I should be restrained from making any kind of construction. Yes. And then he moves an addendum or prays for addendum, which is granted. Ex parte addendum granted. And the suit filed in 2022. It was granted. After that, I appear, I contest the temporary injunction. Temporary injunction not granted. Refused. Refused. Misappeal preferred. In misappeal, in misappeal, they file an order 39 rule 7 as well as order 39 1 and 2. 39-7, yes. No, now in the appeal he changes, plaintiff changes the tack. He says, no, sanction plan may be there, but in violation of the sanction plan, I am making construction. His plaint was, I am making construction without sanction plan. In appeal he comes, I am making construction violating the sanction plan. There is a difference between the two. And now there he gets, at the first stage, Lordship kindly says, he gets an addendum order of injunction. Again, from the appellate court. Be that I have, which trial court has recorded that I have a sanction plan. While dealing with the, then order 39 rule 7 granted ex parte. Ex parte on the very first day by the learned district judge. Even in the appellate stage. Yes. No, but in the facts and circumstances, Yes, authorities are there. Yes, yes, my lord. Barrister has a fabulous memory. Now, after that, Advocate Commissioner acts on that. I did not accept that order, but it is parts ex parte came, it has been done, measurements done. We did not challenge it. We did not challenge it. It is filed. I enter my appearance. After I enter my appearance and start in the appeal court and start contesting, repeated time has been taken by the plaintiff appellant. Then one fine day, when the hearing has been done, he withdraws the appeal. After withdrawal, within 7 days, he comes back. I made a mistake. Appeal should be restored. Learned Appellate Court records that appeal has been withdrawn under misconception and being misled by the respondent, petitioner, defendant. And then he directs service. After couple of also injunction restored. And then, without serving me, granted, makes the injunction absolute. That is why I am before Lordship. Though the court records that service has been effected on the subsequent stage after the restoration of the appeal, but my client says no service. I know that it has to go back because of the 1982 Supreme Court. Wrong recording. I know that. Yes. No, that is one of the point. My lord, on today's date, there is no misappeal. Call. Yes. Court records that it has served. Client says not served. I'll come. Maybe. No, my lord. Can it be kept day after because it's Midnapur? Monday. I'll come. I'll be. Because that in the, yes, because extremely urgent. Yes, my lord. At some point, you have to accommodate us. I was telling my friend that we are under watch. No, I think my Lordship will have to fix a date for Thursdays. Whole day. Applications, restoration or some other applications will start coming. Because there is a huge pendency, my lord. Because from pre-COVID days, it started piling up. At least 35 matters get filed. Not Monday. Without hearing me, the temporary injunction has service. And the observation in passing the temporary injunction that I have misled the court. Because I have annexed entire order sheet. Yes, prior order. That order also I have challenged. I have challenged the entire order sheet after restoration of that. Because one thing is service or not service. Second is the remarks. Yes. That has to be. Yes. No. That is. Yes, it is there.
Seven.
Ashif, for the petitioner lordship, this is an application for expeditious hearing of the title suit for recovery of khas possession. During the pendency of this revision application, the injunction application has been disposed of. All that remain is the suit, and I'll be paying for direction upon 2017, 2017. That Tolaram India Limited versus MS Bharat Teen and Enamel Co. Private Limited. Yes, my lord.
17, 20.
My lord, I apologize, my lord. 2021. My lord, 2021, my lord. My lord, but tomorrow the date is fixed for a framing of issues, my lord. No, my lord. For expeditious hearing of the suit, my lord. Okay. I apologize.
Landlord of
Lordship, I'm the petitioner. Mr. Piyush Chaturvedi is leading me. Mr. Piyush Chaturvedi is leading me. He is, Lordship. Lordship, it's the occupational charges, revision of the occupational charges, Lordship. Lordship, I'll just. Yeah, that is an order from that was an appeal order, Lordship. So the revision is here. Okay. Lordship, in the first court, we lost the matter. Of rupees 14,000, Lordship. Lordship, that is, we are just challenging this, just revising the amount, total amount. Lordship, the only thing is that, Lordship, the occupational charges, Lordship, is our contention is that it is not in accordance with the
paid to him.
It's not in accordance with the market
not
value,
being
Lordship.
paid.
We are just contesting that it is overvalued. We are ready to pay, Lordship, but in the market value. That is it.
Correct. That market value will be decided.
Lordship.
Market value has to be decided. If he
Lordship,
has not decided,
Lordship, that is the order.
finally decided this.
Yes, the Lordship, that yes, that was finally decided.
50 per square feet. It's a Chandan Nagar 700 square feet commercial area. Court reduced it and said no, 14 will be our amount.
I will examine this.
Lordship, Lordship, I'm just praying that.
Challenging you deposit this amount. Challenging.
Lordship,
I will examine this.
Lordship.
But without.
I will examine your case. I am not throwing out your case. I am admitting the petition.
Lordship.
But you have to go on depositing this. Now, if you ultimately do not succeed,
yes,
then
that is
the Mami has to go to him.
Lordship.
If you succeed,
Lordship.
this will be reduced. He will the registrar will deposit in an interest bearing account. And if he applies in the meantime, what according to you is the rate?
Lordship, we had actually specifically said that the order.
No, what according to you is the rate? Tell me. It is not 14,000, it is 7,000 or 10,000. What is
Lordship,
the
yes,
figure?
because we assess the rate to be around 300 to 500
That is the
per
contractual
square
rate.
per square feet, Lordship, and they have said it has been 700. That is the only difference, Lordship.
So if it is 500, so how much it will be, Mr.
300 to 500.
700 square feet.
So it will be 7,000. I will
300, Milord, it will
I will grant you liberty to withdraw 7,000. I will grant you liberty, admitted amount. I will grant you liberty to withdraw 7,000. Balance, she will continue depositing subject to the result of the application. I'll admit your application.
Lordship, Mr. Chaturvedi is appearing, Lordship. That is, maybe.
He's coming. He's coming. So I'll admit the application on that ground.
Lordship, if yes. No,
He's come, yes.
Yes.
Your application will be admitted. You,
Lordship,
you look at your facts, you place your case.
Lordship.
Don't look at your senior. He'll
No,
be
Lordship,
here. You are saying, madam, two aspects are there. Two aspects are there. One aspect is that certain amount is admitted.
Lordship.
So admitted amount you have to pay.
Lordship.
There is no dispute with regard to that.
We want to pay also. My
There is a
instructions are
disputed
clear.
amount apart
It's
from
only
that.
the amount of, Lordship,
There
that
is,
we are
apart from that, there is a disputed amount. Disputed amount you deposit.
Lordship.
You deposit the disputed amount. I'll hear Mr. Chaturvedi is here, I know. So admitted amount is according to you 50% of this amount, more or less.
Lordship. That is.
I'm not recording that, but more or less it will be 50% of this amount. So 7,000. Yes, Mr. Chaturvedi. 7,000 will be admitted. I'm not recording admission.
I don't know, my lord, where does my learned
No,
junior
don't
friend-
run, don't run. Ask your junior to you please sit down. You sit down for a while.
No, my lord, I'm comfortable.
You see, today a decree has been passed. You have preferred an appeal. You have to pay occupational charges. Right, wrong, indifferent, bad. The learned judge has decided the occupational charges today. You have come up. You are saying that this occupational charges is not correctly assessed.
Chandanagar 700 square feet.
Wait, that I have to examine that, whether it has been correctly assessed or not, to what extent I can go into this. These are, Mr. Mukherjee will not leave a bit on this. He will argue the entirety on this issue. Today, question of admission. On the case of admission, I will hear out your matter. You deposit with the register original site. I'll grant him leave to withdraw 50% of this amount, and the balance will be subject to whatever is decided here. I'll place it for hearing. But you have to deposit. Without deposit,
No, the deposit of entire occupational charges, Lord, would operate as if it is a decree and I am challenging it. Kindly. Lord, kindly see the finding of the learned court below.
Yes.
No likened property or its rental was shown. Atmaram properties, my lord, kindly recollect.
That is why I will hear you. Today you cannot get it heard, Mr. Chaturvedi. Can you?
No,
Cannot get it heard?
No.
What I am doing is I am fixing certain matters for Thursdays, as I was doing in the earlier determination.
yes.
So I'll place it on Thursdays and take it up. But decree has been passed, you have to secure.
No, this is, my lord, that is what I am saying. This, my lord, is not akin to a decree. This is, my lord, only occupational charges, tentative order based on the materials. Now, my lord, can't see, my lord, whether it is based on any material. Admittedly, neither.
I have to examine that. Whether it is based on material or not based on material, I have to examine that.
I pay 50%, my lord, directly to him. But kindly do not, my lord, impose the condition of paying the entirety of it.
No, not to him. I'm not directing you to pay to him.
No, he's withdrawing.
He'll be withdrawing only 50%.
Lord, that is what I'm saying. Lord, I said
for the time being, I may not direct that also. For the time being, I may not direct that also. But you have to deposit the entire amount. What has been decided today. Because today there is no material before me to consider to put it down, to decrease it. Because I have to hear you. Without hearing you, at this stage, harakari. The learned judge has decided this. I say, no, you put in 50%. That will not be fair.
No.
I have to give reasons for whatever I do.
Yes.
So,
it has been done in January 2020.
No, that is different issue.
That's why, Lord, already 12 months also passed.
No, he has filed the application long back. He has filed the application in March.
Yes. Immediately after we got the certified copy.
So not that. He has filed it in March. He cannot be blamed for this. It was not taken up.
But I am on, my lord. This is a condition for my lord enjoying this stay. So the my lord.
Yes, he has succeeded in enjoying the stay. That is why I put him to condition. I am aware of the situation, but he had no fault in having it delayed.
I cannot, being an officer of the court, I cannot.
He immediately, the moment the matter was called on, his junior was here and he is here, both. So I'll hear it on another day, Mr. Chaturvedi. I'll admit your application and I'll direct you to deposit this this whatever has been directed with the register original site.
In 2 installments, my lord, because
Yes, whatever you want. And that's why I wanted to ask from you, you cannot stay there without payment of occupational charges.
I followed.
I have to direct some amount to be paid to him. So that is why what would be the reasonable amount? According to you, 300 to 500. Your junior said.
Yes.
And she has decided 700. Correct?
Yes.
So if I accept 500, it will be more than 7,000 rupees, much more than 7,000 rupees. Total, naturally. So therefore, 50% of the amount which you are depositing, I will permit him to withdraw. Occupational charges you have to pay. You are occupying the property after all.
No, Lord, kindly.
Yes,
then,
tell me. I'll hear you on this. On this, I'll hear you.
Yes.
This point, yes.
14,000 has been directed to be paid per month.
Correct.
And
you do not pay that. You deposit that.
And 300 to 500, which my lord is now taking, is per month. The cumulative amount comes to about 7,000 rupees.
Yes. No, more than 7,000.
About, let's say, let us say, my lord, that it
On
is.
the lower side, I'm keeping it to 7,000. Say 4,400 will be 7,000 rupees.
Very well, my lord, let us say, my lord, 500 rupees would, my lord, take us, my lord, to about 8,000 or 9,000
Yes.
rupees. Maybe. Well, we give a benefit, my lord, let it be 10,000 rupees. My lord, if this amount, my lord, I pay, this is not 50% of what has been directed by the court, because court has directed 14,000 rupees per month.
Yes.
My lord is asking that the 50% of that amount
will be deposited.
Yes.
Only deposit.
I am depositing, my lord, 50% of
Let
the
me see the order. We'll come to the order.
Yes. 300 takes us to about 8,000. The court has directed 14,000 per month, which for 10 months would come to about 1,40,000.
Correct. So this 14,000 per month was directed to be deposited in 6 installments. I'll give you some installments. That is a different issue altogether.
Yes.
Out of the amount you deposit in court, I will permit him to withdraw 50% of that amount. Withdraw, because he is entitled to that.
Yes, but my lord is saying, my lord, 500 rupees per month.
No, not on that. 50% of the amount, subject to final determination at this stage, whatever is decided here.
No, but then, my lord, I have deposited. He is secured.
You have not deposited.
No, I say if I deposit, he is secured.
No, he's entitled to it at this stage, not security.
I'm coming to that.
Yes.
So I have deposited. He is secured. My lord, permit him to withdraw to the extent that, my lord, at the moment, my lord, is an admission that yes, 500 rupees is an admitted amount. At least he would get this much. So that amount, my lord.
How much will be 500? You tell me.
500 per month would, my lord, now about.
You tell me, Mr. I will take it from you and put that figure right there. You tell me.
Lord,
you tell me.
10 months, 500.
No, not like that. You are staying there. Every month you have to pay.
From the date of passing of the decree, he done a trial yet.
Yes.
He has done that. He cannot say 10 months.
No, very well, my lord. For the entire period, whatever amount, my lord, is there, my lord, at the rate of 500, I'll pay. He'll
not pay. You deposit in court.
He'll withdraw.
Yes. No. Tell me the figure.
Yes. My lord,
I can't ask the Registrar General to calculate.
No,
you tell me the figure. I will permit him to bid.
I should.
Yes.
Lord,
Take your time and tell me the figure.
No, we come back with the calculation on the next day. At the moment, my lord directs my lord instead of.
No, arrangement, not.
No, Mr. Mukherjee, wait. I not called upon Mr. Mukherjee. Have you been called upon? Take your seat.
I deposit the entire amount.
Yes.
Let him withdraw 25% of the amount. We come back.
No. What is the admitted position? You tell me, Mr. Chaturvedi. You are.
No. I should.
Whatever you say, I will accept it and I'll direct to be permit him to withdraw.
22. September 22. There 2 years, 24 months, 24 into 14,000.
Forget the months. Only give me the rate. Because whatever you deposit, you have to deposit in terms of this order.
Yes, 14,000 per month.
Per month from the date of the decree.
Yes.
From the date of the decree, and you have to continue depositing that.
Yes, my lord, I am conscious.
Yes. And I will take up your matter for consideration only at least till such time you pay this, unless till such time you pay this amount. If you ask for installments, give you installments. But after the payment is made, I'll take up the matter into consideration.
after
So
the entire
earlier the pay, better it is. Earlier you pay, the better it is, because your matter will be taken up into consideration.
It's getting
Both ways.
onerous, my lord.
No. 14,000 may not be onerous.
Lord, kindly see, my lord, 700 square feet Chandan Nagar.
The learned judge had reasons for this. Please understand.
And based on
I will examine this to the extent permissible, because Mr. Today I cannot say I will go into each detail. You have to show me that the learned judge ought not to have taken into consideration these aspects and had overreached. So you have to show me that. I cannot go into the factual figures. Please understand.
Lord, I would not, even when
I know that because you will not go that far. You will only keep with your arguments within the boundary.
I wondered what is this order based on? Because neither parties, the court records, neither parties have been able to produce.
To consider that, Mr. Chaturvedi, I have to hear the matter.
So I am not on quantum. I am on, Lord, the manner in which it is decided. And that would be, Lord, argued when my Lord hears.
Absolutely. You tell me figure.
Lord, if we compute, my Lord, at the rate.
You tell me the figure. I will accept, Mr.
Lord, 14,000 entire, or my Lord, the amount which he is to withdraw.
No. Entire amount, and thereafter you tell me he is to get this much. According to you. That is the reasonable rate.
3,36,000. 3,36,000. Because the last of the occupational charges to be paid would be until September, October month.
No, forget that total figure. What is the monthly occupation charges according to you?
Lord, according to me,
you must be having some. You can't say there is no occupational charges.
Lord, I am saying, Lord, it is 500 rupees.
500 rupees. Per square feet. Per square feet. 500 per square feet, naturally.
No, 500 per square feet, then it is 700 square feet.
So they have to calculate that.
No, 500 rupees.
So how much?
For the shop.
Oh, 700 rupees for 700 square feet for 500 rupees, 700 square feet.
That is what, Lord, is the prevailing, Lord, rate of rent, Lord.
Show me.
Tin shade.
Maybe show me. Not even 1 rupee a square feet.
Lord, tin shade, my Lord.
Lord, reasonable, Mr. Chaturvedi.
Lord, I leave it to my Lord. My Lord, if my Lord says that it, my Lord,
I am not saying anything. I will decide that later.
Lord, it is 20.
Being agree, challenging, Ashun.
Lord, 20. It is only one thing. Lord, it is 24 months. My Lord, kindly, my Lord, says, my Lord, what amount is to be calculated.
Challenging the judgment and order dated 23rd of September 2022
application pendency doesn't have any bearing with regard to the hearing of the appeal because it's their appeal.
Pendency of the revisional application. I have confined it to the quantum only.
But Lord, sometime Lord,
Pendency of the aforesaid revisional application shall not stand in the way of early disposal of the appeal.
Lord, I am more concerned.
No, how can it? Unless he deposits
Lord, that is the condition for stay of execution
Acha.
case.
early disposal of the appeal.
Yes, that's right. Lord, I am more concerned with that.
Early disposal of the appeal. Only have you are happy.
Yes,
You
yes.
don't want it to be disposed of early.
Why not? Only thing is that, my lord, the stay granted, stay of execution case would continue.
Subject to the condition of your lordship's order.
The interim order passed by the learned. No, you are not aggrieved by that.
No, I am saying
you have not you are not aggrieved by that.
no, I am not aggrieved by that. Today, my lord has.
I have said that your revisional application is only confined to the.
My lord is interfering with that part of the order. Now,
so
the learned court has
without cover.
Yes.
So there is no cover.
Yes.
Very well. There shall be an unconditional stay of the title execution case number 28.
Simultaneously filed. One filed by the landlords against us for eviction of tenants, another filed by us against the landlord for declaration of our tenancy. And
Lucky enough, you did not seek for eviction of the landlord himself.
now, my lord,
Yes.
there is only one distinction between two suits, that the properties are different, my lord.
That the properties are
Different. In the suit for eviction, the holding number of the property is different. In my suit for declaration, the holding number of the property is different.
no analogous hearing in that case.
Yes. Now they prayed for analogous hearing, and that has been allowed, my lord. I am
Allowed?
Yes, that has been allowed by the impugned order. I am challenging that, my lord. Kindly see the impugned order. The learned court below presumed that the description of both the suit properties are same.
Challenging the order dated 30th of January 2024. No, not 30th. Challenging the order dated 8th February 2024 List this matter list this matter in the monthly list or returnable motion. Monthly list of December. You can complete or not possible January when I direct.
No, I shall serve them and come back at December.
Petitioner is directed to file affidavit of service on or before the matter is taken up next.
Great.
আরেকটা ডাকো।
Auntie.
Not in this matter, my lord, Mr.
করবো স্যার, the audience side এদিকে। ভালো আছে, সব ভালো। ঠিক।
May I mention one application in connection with Dunlop matters, which is pending but not appearing in the list. Next week. I am mentioning today.
Sir, I appeal for the respondent. We have not been served with the application. It's clause 13 application of 2013. Yes. Great. Yes, my lord. Right. Very good. Lordship. No. I have no. I'm giving no consent. Yes. It does. I am not. No contest on that. I'll run away. Great. Absolutely no.
But I appear for the petitioner. This is an application under clause 13. Affidavits are complete. Yes, point is short. Point is very short, my lord. That I filed a suit for eviction in the city civil court. Well, this is a I am, my lord, Karnani Properties Limited. One of the suit properties in Park Street, my lord, Karnani Mansions. The suit 2010. I had filed a suit, my lord. This is under the Premises Tenancy Act. My suit is under the Premises Tenancy Act. Old tenant covered under the statutory protection. My lord. Karnani's. No, this is a company. Karnani Properties Limited company. It's, my lord, where, my lord, all these chain of restaurants are there, my lord. In Karnani Mansion, my lord, we have. No. Lordship, no, that lordship will have nothing to do. Lord, I'll tell you a very short point. Lord, I file a suit under the West Bengal Premises Tenancy Act for eviction. Grounds or eviction, my lord, are the threefold usual grounds: non-payment of rent, addition and alteration, and subletting. Subletting being one of the prime grounds. Now, in 2010 suit, they file a written statement. They deny three things. Number one, they deny that I am the owner of the property. They deny they are a tenant of the property. And of course, they deny everything. So, my lord, it's that
written statement is denial. Then, my lord, 2010 to suit, it has proceeded to trial, but nothing has happened, my lord. Only one of the witnesses have been examined. It's, my lord, as it is. Then, my lord, in 2015, we come across an order where we find that the defendant in my suit has filed a suit for eviction against the occupant, whom we say, my lord, there is a subtenancy, somebody else is in occupation. That is one of our grounds. I am not saying that he is not entitled. He has filed a suit where, my lord, a sheriff was appointed to file a report who is in possession, and that is there. And that plaint, my lord, my entire case has been almost admitted. Now, all I am seeking is, now, my lord, I cannot transfer this suit, the High Court suit, to City Civil Court because of pecuniary jurisdiction. I cannot transfer it to there because, my lord, of pecuniary jurisdiction, because they have valued it. Valid, yes, it satisfies, my lord, the classical test, my lord, of clause 13. My lord, those 8 or 10 parameters laid down in 1951 Calcutta, my lord, I shall show it satisfied 2 or 3 of the primary ingredients over there. So, my lord, I cannot transfer this suit over there. So, I am seeking the transfer of my suit over here primarily for 2 reasons. No. Well, my suit has proceeded. It's proceeding in trial. Trial has only commenced of one witness. We have stated. My suit is in City Court. Their suit is in High Court. Nothing. My lord, and they can't be inconvenienced. Because, my lord, their records are here. And, my lord, if my suit is transferred, my lord,
I'm opposing transfer. But whenever convenient. Except next Monday, any day. And your lordship is taking up at 3:30, because next Thursday I have a matter at 2 p.m. fixed. So if it is at 3:30, I do not have any problem. Yes, ma'am. But I am day after tomorrow. No, but I have a matter fixed on 14th at 2 p.m. Whenever. Yes, ma'am. 14th. But both matters identical, my lord. 2 and 3. 2 and 3 are identical, my lord.
is it my lord's pleasure to fix a time? Very good.
But if your lordship takes it up at 3:30, then 14th is fine also.
But then lordship can keep it on 14th also.
Then 14th is fine also. I have a 2 p.m. fixed. Very good.
The 2 and 3 same order can.
Lordship, I appear for the petitioner's lordship. This is my application under clause 13. Lordship, the parties have settled the matter, lordship. I have instructions to withdraw the case, lordship. I'm carrying the instructions in writing. Grateful.
I was for the respondent, my lord. Yes, but my lord, this suit. My lord, the thing is the suit. I'm for the respondent. The suit that they are seeking transfer of, my lord, has been withdrawn by them. The suit has been withdrawn. My lord, then subject to my lord's correction, my lord. Very much. My lord, I will lose my chance to get them. I will lose my.
Not, this is a partition suit seeking transfer to the High Court. I tell your lordship why. Here, rule has been issued, rule has been served. All these formalities we have completed. The only property is yes. There is no answer to the rule. In fact, before in the Alipur court also, the defendants are not appearing. There is a deputy sheriff's affidavit is there, not? Look, the defendants group are the family of the brother and sister. That's defendant number 3. That's paragraph 3 has been received. Srimonti and Shamrit, the other. No, I've got a copy, I've got a copy. Yes, Lord. Sri is that's me, Lord. I also, Lord, your lordship will find that, Lord. Lord, she's alive, Lord. Yes, Lord, page 3, your lordship will find that Shumona was not there at her residence to accept the rule. Yes. Now, Lord, I was only trying to say this. The entire reason why this clause. Lord, would your lordship direct service on her, not again a rule? I tell you, lordship, why? The rule means again the rule will have to be redrawn and served. Lord, I tell you, lordship, Lord, why, Lord, I have come before your lordship. Lord, this is a partition suit between the sister and the brother. Yes, sir. No, they are not appearing even in the Alipur court. There also it's proceeding within the absence of the other side. Lord, the trial is going on. Now, Lord, if your lordship only passes an order directing service on the 3 defendants with a direction to appear before your lordship on a day, but what I would suggest, what I would submit before your lordship on that day is that the only property is a 1-story building in Lake Gardens area, 4 katas and odd. In our view, it is not partible. Either they will have to, it's 50-50, 50 my share, 50 their share. They will have to buy my share or I will have to buy their share. So I would beseech your lordship on that day, kindly appoint somebody. Lord, they are not appearing, Lord. only my client has gone there and witness and come back. Not what will have to happen is, because in the Alipur court there will be a preliminary decree, there will be a commissioner of partition. It will go on for next 5 years. I want to not sort it out in one day with your lordship's blessings, Lord, with not a mediator being appointed to settle the matter. So Lord, kindly direct service on the respondents and to appear on a certain day, instead of the rule again being issued, because I really don't want to go into an adversarial proceeding. It's not a matter, Lord, where, Lord, we need to have a fight, Lord. It's only because actually what has happened is that the brother has passed away. These are the brother's widow and the 2 children. Now, Lord, there is Lord, Rajesh Mondal is the sheriff's officer. Lord, we have a photocopy of that, Lord, unsigned photocopy. No, that note I cannot say, Lord. The sheriff usually goes again second time. Why that I could not. No, Lord, the rule has to be served. The written rule has to be served. Yes.
Drawn up.
Lord, the rule has to be drawn up by hand. That rule exists, which was served and come back. If it still exists, that rule will be served. Otherwise, it has to be drawn up. Or Lordship, kindly direct service, not I. Because if they come, then we can sort it out, Lord, in one day. This is not a battle to be fought in court. If they are not in a position financially, then we'll buy their share. If they're in a position, they can buy my share. If they can provide some rooms, we can divide amongst ourselves. Now the blood, I am the sister. No, young people. I am the sister. I'm in my early 50s. They are my elder brothers, widow and 2 children. There was no problem. After the death of the elder brother, there's a difference. Now we need to sort out the family things. Nobody stays in the building. We've come to learn, they've taken some trade license from the corporation to carry on some business, maybe creating third-party interests. We want to settle it and finish off the differences between the 2 families. Maybe we can give up a little, they can give up a little, come to some sort of consensus. Your Lordship may appoint somebody as a mediator, or otherwise, if it goes on in Alipur court, there will be preliminary decree, commission of partition, things will go on and on. Very good. Monday.
My lord, in item number 8, I am appearing on behalf of the respondent number 1 and 2.
9.
8.
No, 9.
My lord, nothing is there, my lord. The property is situated in Salt Lake, my lord. The matter instituted in Barasat, my lord. My lord, I am challenging. My instruction is that, my lord.
Lordship, my application.
9. Oh,
9.
9.
Clause 13 application, Lordship, by the State Bank of India. Lordship, the differences arose between the parties, Lordship. Actually, there was a bank guarantee given in connection of a contract, Lordship. Bank guarantee was given by Braithwaite to Coal India. Now, they had their differences. Work was not done. Now, Coal India wanted to invoke the bank guarantee. There was an injunction.
A suit was filed in the Alipur court, lordship. Injunction went on for some time. In appeal, the injunction was set aside. Now, immediately, Coal India asked for the money. State Bank gave the money. Now, another suit has been filed in the original side by Central Coalfields that you have paid the money, but there is a delay. So we should get that money. That is going on, lordship. Both suits are going on. Now, same documents transfer, because most of the documents have been filed there. Now, evidence stage is over here. Now, same documents are required here. So, lordship, it would be better if the Alipur all documents are issues also. If that suit fails, lordship, this suit will also fail. Or if that succeeds, this will fail, lordship. Then, lordship, I'll come with a list of documents, lordship, on the next day, lordship. Kindly allows me, I'll give the entire list of documents. Because before the commissioner, lordship, they are saying the documents is there, so we cannot produce. Ours is also the same case. We have also filed the document there. Lordship, formal application for lordship, most of the documents, lordship. Grateful, lordship.
Before I make my any submissions, my lord, we are really missing this court. We are really missing this court. This Dunlop matters. Complaint matters of Dunlop. So, no, these are not the complaint matters, my lord. Oh, company matters. I'm so sorry. I beg your pardon. Yes. So now that issue is not there because Justice Sharkar has been given the determination. So not yet decided when she is going to take up her ladyship has not decided that. It's flexible. So we have been able to adjust with Justice Bharadwaj, at least with court number 1 and 759. My lord is sitting there. So with regard to the company matters, Justice Sharkar, her ladyship, she has not decided anything when the company matters to be taken up. I'll let it remain in the list. But so far this matter is concerned, my learned senior friend, she wants her submission to be recorded and also my submission to be recorded because this is an application taken out by one of the secure creditors, my lord. And they have already been paid pursuant to the order of Justice Bhattacharya. No, she's there. She's for the applicant.
I have put the applicant bank and the claim of that bank. They had lodged 171 crore, but oil has approved 51,69,000, 51 crore 69,000 and all. And they have sold out as per their own letter property worth of
No,
it is not appearing for the first time.
Orders have been passed by Justice Bhattacharya.
Already
Now,
we
Justice
have
Bhattacharya, pursuant to the order of Justice Bhattacharya, 18 crores out of 51 has already been paid. There's a balance of 33 crores. Until and unless the assets are being sold, I cannot make the payment. Because she is the preferential creditor, so we have to make the payment. So let the assets be sold and we'll make the payment. That is pending. Sale of the assets are pending, my lord. No point of keeping it on the next month list. Let the assets be sold. My lord's order will be there. And the moment is being sold. No. That
given to the state that oil is having some.
No. How can it be? How under what? Yes, that has to be. That is pending. Next month. In the meantime, if it is taken up, fine. Yes.
Recording our today's submission, if you are also recording, then I will have a face to say something to my client.
Just to justify your appearance, my lord.
Justify my appearance. Yes, Mrs.
No, 51. 51, page 15, my lord, page 15. No, this is the admitted amount.
This was the fund they were having, and my claim is approved to the tune of rupees 51 crore 96.
Page 15, page 15.
401. Page 6.
It says aggregate due. Aggregate due is how much?
51,96,004, page 15.
51
I.
401.
I.
51 crore 96.
00. 0.25.
Then admitted, out of which the OL has paid 18 crore. Out of which 18 crore has already been paid pursuant to the order of this honorable court. By order dated 24th November 23.
18 crores has been paid.
Yes, will pursuant to the
Yes. Yes. Underpayment. Yes, deeply obliged.
maybe January or
January or February, ma'am. Yes, 25. Deeply obliged, ma'am.
you know, this security, entire security, what today was
We have already filed, it's running in the list. But that matter needs to be, either it has to be assigned before your lordship again, because that has been filed.
Miller, one small supposition. Miller,
No, because those Dunlop matters all assigned before your lordship. Then, because then I need to make that submission for releasing the matter, and then shall I? Then, if your lordship, then I can make that submission and get the matter done there, and then on the basis of that order, the sale will be conducted in the meantime. Whatever has happened.
entire property was mortgaged with the bank.
এখন বলে হবে না কিছু। My lord, this is also another application. Here also, this an employee has come up for his making the payment, but already he has been paid that on 2 occasions, 125 and 30 has been paid.
Item 12 is my application. Here, my lord, I challenged the notice of rejection by the official liquidator. My lord, my claim was I'm an employee. I have been an employee of the company, my lord, since 1980. My lord, my claim was to the extent of rupees 2 crore 18 lakh, which is inclusive of interest. But my claim has been rejected in toto, save and except 1,27,000. Yes, my affidavits have been exchanged. But I have
Pleadings are all complete, my lord. If your lordship
any
wants
day,
to
lordship will hear this matter out. Well, would not have made this submission, but
Yes.
that kindly sees, my claim, my proof of death is at page 37. Very well, my lord, we shall. I shall.
Monday, my lord.
The new matters will come to your lordship. That- Clause 30, not much.
Hardly there are matters.
Lordship is making it not this week. Lordship is making it not this week. Wait. No, right. Yes, appellate side is voluminous. Grateful.
My lord, Mr. Shantanu Kumar Mitra is applying for the applicant. He is engaged in court number 18. I am paying for not today.
Before Lordship rises, may I be permitted to mention this matter, my lord? My lord, has pleased to grant me leave yesterday, my lord, to file this application without certificate on the appellate side. My lord, my lord, everything is ready, my lord. My lord has been pleased to grant me leave. Lordship has also been pleased to give me leave, my lord. Lordship, yesterday, I beg apology. My lord, I have tried my best, my lord. The filing section was full of civil revision application. It could not be taken up, my lord, to file that matter particular yesterday. Lordship, kindly grant me a date, my lord, if your lordship so desire, lordship.